Hi, I'm gonna do the course that's the Apple Computer versus Microsoft Cooperation 1994. So basically, the long and short of it is Apple had noticed that Microsoft had some very similar software to them on their computer, and they were thinking that since it was so similar, it would be copyright infringement upon them both. But there's more to it. So the stakeholders, Apple and Microsoft. Basically, they went through the district court and they were going through they took apart multiple pieces. So they went through the designs of of both versions between Microsoft and Apple, and they found the similarities and the non-similarities. The interesting part was there was some parts that were not licensed, and so they had to figure out whether that fell under being officially unique enough to stand on its own. And I think they ended up saying it did, and so basically the differences again got them through it. And so Microsoft, they didn't exactly say it for sure, but it basically was what they said, was saying they got not guilty because there was differences enough between them, as well as there was an agreement between Microsoft and Apple, like in 1985, that had said that they were allowed to use some similarities of their products. So that in of itself kind of nullified some of their original agreements. But overall, the infringement, I don't think there was any infringement. I think it got really close to some points, but yeah, that's pretty much it. On the effects in the industry, again, is just saying like differences between companies and making sure you have a fine line about what you want and what your copyright is, I would say. And all in all, I think that you should just check with people at least if you're gonna use their stuff or something similar to it. Just maybe call their company and be like, hey, can we use this little piece or this little piece that's gonna be kind of similar to yours? Maybe then they won't be so high strung about it. But yeah, that's all I got.